Good evening. This is Stephen Leskin, and I am an attorney in Portland, Oregon, a divorce attorney. And every other week or so, I do these webinars on topics of interest to people going through divorce or who have family law issues. Usually, I have a PowerPoint presentation and I don't do the talking head thing. But tonight, we're going to talk about restraining orders. And it's just going to be easier. There's a lot of text, and it's just be easier to talk about it rather than putting it on the screen. So I don't take comments during the webinars, but you're free to contact me through my website or through the phone, by phone or email, and I'll give that contact information at the end. And I'm happy to discuss your situation with you. It's just not a good time during the webinar to do it. Uh, so let's just get into it. There's several different types of restraining orders, and I'm going to just give a quick overview, and then we're just going to focus on the family abuse restraining order, often referred to as a FAPA, for Family Abuse Protective Act. And we'll go over what qualifies, how you get one, how they're enforced, and by the end of the hour or so, you'll probably have a good idea of what it takes to get one, have it sustained, or defeat one if you're on the receiving end. I would also like to start by talking about some of the other types of restraining orders. We're not talking about that. I'm just talking about it right at the beginning here, just to differentiate, so you'll know that there are different types of restraining orders. In a divorce situation, there is a restraining order that goes into effect as soon as it's filed by the petitioner and served, and it goes into effect when it's served on the petitioner. Uh, I misspoke. It goes into effect once it's filed by the petitioner. It goes into effect for the petitioner. It goes into effect for the respondent once the respondent is served. And that restraining order, by statute, prohibits parties in a divorce from wasting their assets or transferring their assets or concealing their assets. And in essence, that restraining order says you can't transfer or sell an asset other than your normal course of life or business. So, for example, if you have cars and you start selling your cars, that would be a violation of the restraining order, unless you're a car dealer or it's a hobby that you've got done for years. The normal course of things would be okay. So that's the first restraining order, and that just applies to property. There's two other types of restraining orders that may come up in a family law situation. They're both stalking protective orders. The first one that we'll talk about is a civil stalking protective order that you can get by going to the courthouse, and you'll fill out the forms and you'll have a brief hearing before a judge. The judge will either grant it or not, and the respondent, the person you're accusing of stalking you or abusing you, has an opportunity to be heard by the judge, and then at that hearing, the judge will decide whether to continue it or not. There's also a second type of stalking order, which is issued by the district attorney, and that's a criminal offense. It's a Class C felony to be convicted of a stalking order. They're both about the same thing, that it's repeated unwanted conduct that harasses or menaces somebody. And one is you can do it yourself, and the other is you can file a police complaint, and maybe the district attorney will take it. If that's the case, then there are penalties for that, including fines and jail time for a Class C felony. What we're going to focus on tonight is the Family Abuse Protective Act restraining order. And as we'll talk about in a minute, it's available to people in familial relations, right? So it's people who've been intimately involved in the past 2 years, husband, wife, parents of a child, anybody who meets the criteria that we'll discuss can apply for one. The criteria that the court will use, and we'll get into this at length in just a minute, is that there is an imminent fear of bodily harm, right? That there's either been past or continued threats and violence towards somebody, and the court can impose a FAPA order on the respondent. Um, if the court imposes a FAPA, there's a very, very wide range of things that the court can do. If there's a house, the court can, or apartment, residence, the court can order the respondent to leave, they not visit a place of work, not have any contact. If there are children, the court may make provisions for the children so that they don't have to have time with the respondent if they're a threat to the children as well, or create a parenting plan, a supervised parenting plan for the kids, or create a way that the kids can be exchanged so that the two parties don't have to interact or have any contact. So it's quite a powerful tool if you are in a abusive situation and you have that ongoing fear of harm. So let's start getting into it a little bit deeper. I've got the statute printed out in front of me, and we're going to go through the statute, and then I'll add my practical thoughts and some past FAPAs that I've dealt with for examples of things. So if you are so inclined, you can type into your Google browser ORS 107705. And that's the start of the FAPA statute. And that's actually contained, of all places, in the divorce, in the section of the Oregon Code that deals with divorce. Chapter 107 is the dissolution of marriage statute. So abuse under the statute is defined as attempting to cause or intentionally, knowingly, or recklessly causing bodily injury. So physical harm constitutes abuse, or attempting to cause physical harm. Intentional is pretty clear, like you took somebody and you beat them, you hit them with your hand. Knowingly is a little bit more difficult to get your head around in this consequence. It means doing something that you're aware of may cause harm. And then recklessly is like, I just don't give a damn, I'm going to do it anyways. And that any of those three standards, any of those three mental states are required for abuse. So let me take a one more type of standard. There's also a standard of negligence or neglect, and that means that like you just didn't care, like something happened, you weren't paying attention. If that was the mental state, then that's not abuse, right? Like I looked away and I ran into somebody. That would not be abuse. That would be an accident. So the standard is a little bit higher than that. It's either I knew about it and I disregarded it, the risk, or I intentionally did it, or I knew it was going to happen and I just didn't care and didn't take any precaution to stop something. And that would be the reckless standard. So, that first one is attempting to cause or actually causing. So you don't actually have to cause bodily harm to be committing abuse. Another example is intentionally, knowingly, or recklessly placing another in fear of imminent bodily injury, right? So you have an attempt or the fear, right? Two different things. In fear of imminent bodily injury. So that's the standard. So the judge, when we go through this a little bit further and you go before the judge is going to be looking for facts to support that I have or you have an imminent fear of bodily harm. Another example of abuse is causing another to engage in involuntary sexual relations by force or threat of force. That's pretty reasonably self-explanatory. Child means an unmarried person under age of 18. So those are all examples of what constitute abuse. Family or household members include spouses, former spouses, adult persons related by blood, marriage, or adoption, uh, persons who are cohabitating with each other or who have cohabitated with each other. And cohabitating in this circumstance isn't roommates, it's people involved in an intimate sexual relationship. Persons who have been involved in a sexually intimate relationship with each other within 2 years immediately preceded by the filing of the petition. So if you were boyfriend girlfriend or boyfriend boyfriend or girlfriend girlfriend or other with somebody for the past 2 years, that would get you um, into the purview of the statute. And then lastly, under this example, is unmarried parents of a child. So parents also constitute a class of people protected under the statute. So let's talk about how we get in. So like that's just the background. So let's just get into like how a person gets into court. The first thing that I will say is you can find the Oregon divorce forms by typing uh, uh, Oregon FAPA, FAPA forms in your Google browser. And that will take you to the Oregon Judicial Department repository of forms. And you look around a little bit and you can find a downloadable packet of forms to fill out. They'll also be available at the courthouse. If you're going to fill out a FAPA petition, my strong recommendation is to do it at home and bring the forms to the courthouse. The court will provide the case number and some other information, but you'll fill in as your name as the petitioner or your name as the respondent if responding. And the important part of this form is responding to the question of do you fear imminent bodily harm? And you will need to history is one good way of saying I got that you have grounds to have imminent bodily harm. And so you are going to want to think about all of the examples you have of times when you had fear that you were going to be hurt. For some people, it's very clear when that is. Other people, it may not be so clear. Um, Words alone don't count unless they are specific bodily threats, right? So somebody, go get hit by a car or something like that. That's not it. I'm going to run you over. That's different, right? That's a specific, credible. I don't know if it's credible, but it's a specific threat that can lead to imminent fear. But a general statement about ill will or something to bodily harm isn't going to be enough. It needs to be, if it's words, it needs to be a credible, specific threat that leads to fear. Like, I'm going to kill you, or if you come home tonight, I'm going to beat you, or if you don't get off the phone, I hit you with this chair, right? So those kinds of threats, particularly if they've been coupled with past actions or some kind of physical contact. Somebody says, if you don't get off the phone, I'm going to hit you with the chair, and then they grab for the chair, imminent fear of bodily harm, right? So it's the two things together that you need to look for. So the statute, I'm looking at the statute now, petition to circuit court for relief and burden of proof. It's chapter, you can search this yourself. You can go to Google and search ORS 107.710. If the person, any person who's been the victim of abuse, and we went through abuse, within the preceding 180 days may petition the court for relief under the FAPA statute if the person is in imminent danger of further abuse from the abuser. So supposing a victim gets hit over the head with a baseball bat and the person is hauled off to jail, the abuser is hauled off to jail. Are they in imminent fear of bodily harm? If they're not getting out of jail, the answer is no. You won't get a FAP under that circumstance, right? Because there's no continued fear of imminent bodily harm. If the person is released from jail, then and you apply within 180 days of the abuse, then certainly that would qualify. The So the abuse has to be within 180 days of the time of filing the petition. If you wait those 6 months and then on the last day come in and say, okay, I got hit by it on the head with a baseball bat, um, intentionally, um, you will not have as strong a case as if you happened like the week before or the day before, right? So immediacy is also important here. Like the court will be, well, why did the court in the back of his head is going to think the judge in the back of his head is going to say, why are you waiting? But if you do it immediately, you're going to have that much more credibility and probably bruising. Uh, so you don't want to wait on this if you think that you are going to have more fear or there's been a history of it. Um, uh, you need to act on it reasonably soon. Um, so you'll fill out the petition. My recommendation is you do it at home, thoughtfully, focus on facts, not opinion or not conjecture, but you're going to lay out your specific facts. This is what leads me to have fear, right? Is this a fact? Yes. Is it not a fact? Then it stays out. You want to be as factual as you can when you're completing the petition. The petition will be broken down into two sections. 180 days and anything preceding 180 days. If you don't have anything in that 180-day window, you won't get the petition for the FAPA won't be granted. If you have some things in that 180 days, but more things prior to that, the court can then consider the prior 180, the period prior to 180 days, particularly if there's an ongoing pattern of abuse. So you want to be prompt in getting these filed and specific when you file it. The court only needs a preponderance of the evidence, right? You don't have to prove certainty to the court that you're going to be a victim of further abuse. It's just more, it's a preponderance of the evidence, more probable than not. Like the typical way it's explained is like 51% certainty, not 100%, not 70%, 51. Yes, it's likely to happen. And so you don't have to prove this with an affidavit from God, right? It's likely to happen. That's all it takes. It's a typical standard for civil action in a court. So what happens is you bring down the filled out petition or you fill it out in court. Many of the courts have a resource center that will help guide. They can't give legal advice and they'll tell you that, but they will guide you through the process. You file, generally, things are different in each county in the state, but generally what will happen is the the petitioner will file the FAPA petition in the morning, and then in the afternoon after lunch, you come back and make a brief presentation to the court about why the FAPA petition should be granted. And I just said a brief presentation to the court. The court's going to ask you about it. It's not like you have to have a prepared statement, but the court's going to say what happened on this date, what happened on that date, and the court's going to be evaluating the petitioner for credibility. In my experience, they're going to be looking for, did the abuse happen within 180 days? If so, it's more likely to, if not, then it won't be granted. If you don't have any examples from within the last 6 months, by law, you can't win on that. The court will be evaluating your credibility, but the court doesn't want to be wrong. So as long as you're giving specific facts, the court knows that the respondent has the opportunity to come in and contest and request a hearing and contest the petition, right? So the court's going to err on the side of safety for somebody, right? But you have to come in with facts. You have to come in prepared, and you have to be able to say, this is what happened, right? And the court will, as long as you're like meeting the statutory requirements, like if you come in and say, yes, I got hit in the head with a baseball bat 3 times. Do you have any fear of imminent bodily harm? No, he had a heart attack. He's in the hospital now and is not going to get out for a year. Kind of crazy scenario, but the court's not going to grant it because you don't have any imminent fear of bodily harm, right? If the person is in imminent danger of further abuse from the abuser, right? So if you like, no, she's in jail or he's in jail, right? Then the court can't grant it under those circumstances, right? Because there's no ongoing fear. Uh, so, um, so you'll go to court. You'll fill out the petition. The court will have you back in the afternoon. You will make your presentation to the court, and the court will uh, grant it or not grant it. You'll know right then. If the court grants it, then the sheriff will serve the restraining order on the respondent, the abuser, and the abuser has 30 days to file a request for hearing. There's a couple dates to be aware of. If there are children and custody is involved, the court will have the hearing within 5 days. If there's no kids or no exceptional circumstances, the court will then have the hearing um, within 21 days. By statute, they're required to do that. Sometimes the court will grant an extension so somebody can get an attorney, but these hearings happen quickly, so you have to be prepared for it. If you have so if you are the petitioner and you have evidence, photographs, video, witnesses, you want to have those lined up. Uh, you don't want to wait till the request for hearing gets filed to have those lined up. You want to be thinking ahead of time. Um, what evidence do I have that will support this? And I need to get it lined up. If you have a friend or neighbor who's actually seen and can testify that they've seen the abuse, or there's a police officer or a police report, you want to have all of that lined up um, at the time that you file a petition. You don't know that there's going to be a hearing, but if there is a hearing, it's going to come around awfully quickly, particularly if you need records. If you want to get medical records or police reports, then those just take time, and you won't have time if you wait to the petition and then you have a week or a month before you get, the other person responds. You'll just run out of time. So you want to make sure that you have your photographs ready to go. There's audio, video. You want to have those ready to go. If you intend to bring in a police report or a police officer would be better if you can line that up. In the event that there's a hearing, not on the petition, but on the hearing. So the respondent has 30 days to file a request for hearing, and then the court has to have that hearing rather quickly. So let's go through what things are restrained and what else the restraining order can do. So this is what the court can impose just with one person's testimony, right? So it's a very powerful remedy if you're in this position. So the court can order temporary custody to the petitioner, subject to the rights of reasonable parenting time. If there are safety concerns for the children, the court can impose supervised parenting time or no parenting time. The respondent can be required to move from the residence, regardless of the ownership or rental agreement. Even if it's the respondent's house, the respondent can be removed. The respondent can be restrained from coming within a certain radius of the residence. A police officer can be ordered to help the respondent. I misspoke. Help the petitioner remove personal effects of the respondent, like including clothing and toiletries and medication, certified copies of birth certificates, things like I misspoke. Certified copies of records of live birth, social security cards. The respondent can be restrained from intimidating, molesting, interfering with, or menacing the petitioner, or attempting to intimidate, molest, interfere, or menace the petitioner, right? So either uh, either the attempt or the actual act of menacing or intimidating is a violation of the restraining order. Or their children. Um, the respondent can be restrained from coming into contact with the petitioner at work or the work area. Um, the court can make provisions for the kids. Um, uh, and the most important part is that the respondent can be ordered not to have any contact uh, with the petitioner by in person, by phone, or by mail, right? So it cuts off all contact. Um, and in that case, you are almost certainly in lawyer land because the no contact also extends to third parties. So you can't have your friend contact the if you're the respondent, you can't have your friend contact the petitioner. Um, the order is effective for 2 years, right? So it's order the restraining order will last for 2 years until it's modified, dismissed, or superseded by a divorce. All right. Um, so that's some other thing that all right. So those are some of the things that that can occur as a result of getting the restraining order, right? So no contact out of the house, out of work, kids are protected. There's provisions for an exchange of property, and uh, the only option that the respondent has is to file a request for hearing, and that's done through the court. So usually, if an attorney is going to get involved, it's at the hearing stage. Hearings um, uh, can last an hour, they can last 2 hours. I once heard of a case that a hearing that went on for 3 days. Unbelievable, but they can go on for quite some time. And it's the petitioner's burden to show the person who's filing the FAPA. It's that person's burden to show that they were abused and that um, they continue to have the imminent fear of bodily harm. I want to go back to some language here. Just one second. Language. Hear me shuffling through my papers. So the language again is that that the person is in imminent danger of further abuse from the abuser. Um, I just want to read one sentence here. Um, so this is the key sentence for getting the petition, right? So I can't quite visually, verbally underline this, but I just want to come back to this. Um, Upon a showing that the petitioner has been the victim of abuse committed by the respondent within 180 days preceding the filing of the petition, that there is an imminent danger of further abuse to the petitioner, and that the respondent represents a credible threat to the physical safety of the petitioner or the petitioner's child, the court shall, if requested by the petitioner, grant the petition. Right. So that those are the standards that's the language that the court is going to be looking at. Right. So four things. Upon the showing that the petitioner had been the victim of abuse within 180 days, imminent fear of a credible threat to the physical safety of the petitioner. And physical safety is important. I sometimes get the question of, well, the respondent emotionally abuses me. That doesn't cut it. That just does not cut it all. Um, Emotional abuse is not what a FAPA is about. A FAPA protects purely against the risk of physical injury. And like I said a little while ago, the threat of injury, it's not, it can only be sufficient with words and verbal abuse if it's specific and credible, right? Not general and vague, not like hateful things, but they have to be very, very direct threats before the court will consider that as a credible threat. And it also, in my opinion and my practice, needs to be coupled with some physical action to verify that there's no ambiguity that this is a real threat. So um, I want to talk about how, as an attorney, when I've represented respondents at the hearings, how I've won, right? And when I tell you how I won, you'll see how you prepare. So usually, uh, the respondent will prevail at or many times, I should say, the respondent will prevail at a hearing if there's an absence of things. There's no medical records, there's no police report, there's no witnesses, right? There's communication after the alleged events that is normal or um, is doesn't mention anything about the threat or continues like a normal pace of conversations. I once defended a young man years ago who his girlfriend had filed a FAPA, and uh, our argument was, there was no police, there was no medical records, there was no photographs, and was telling him, well, the text between them, she continued to refer to him as love, and I think that as I recall, she was like, "Can you please pick up some Ben and Jerry's on the way home tonight?" Or something along those lines. The day it happened, and like the judge was, well, there's no threat there, right? So you want to be looking at what is, if you're defending it, you want to be looking at if you've been accused and you're the respondent and you filed a request for hearing, you want to be you want to point out all the things that like are not there, right? All the indicia of somebody having fear. Um, if somebody doesn't move out of the house, if they don't, um, which is not uncommon for domestic violence. So, like, domestic people who are victims of domestic violence want to tamp the situation down. They want the situation normalized, right? So that's just a tendency of people who are like victims. They don't want to cause more problems. They want to become invisible. They don't want to make more waves. So they try to make the situation as normal as possible. So, as a judge once explained to me, that I was cross-examining a petitioner who had filed, and she got later that night. She crawled back into bed with her abuser, which would be a horrible thing, like a legitimately horrible thing. And I said, well, why didn't you sleep on the couch? And after the hearing, the judge was like, no, this is a typical pattern to um, this is a pattern to attempt to normalize a situation. So you kind of have to be careful about like what you point out. Um, to me, it was like, well, if you like had that much fear, sleep on a couch, sleep at a friend's house, take the kids and go to your parents' house or something along those lines. And the judge was like, no, this is not in her mind, the judge's mind, that my line of questioning was off limits because um, particularly abused women, want to normalize. So um, you want to be careful what you point out as, or cognizant, I should say, of the dynamic of what is missing. It's certainly fair game. You didn't call the police. It's certainly fair game. You don't have any photographs. It's certainly fair game. Um, uh, you had dinner later that night, or were still showing signs of affection to the abuser. Um, but you want to be careful that like some of that may be, an attempt to um, reduce the conflict and de-escalate. So um, that's the way you look at this going into it if you are requested a hearing and you're defending against an accusation of abuse. If you and so the flip side of that is how do these prevail? And they prevail by bringing in photographs um, of scarring or bruising, of witness testifying, of uh, um, police reports, neighbors coming in and saying, "Yeah, we heard the screaming. We saw her running out of the house. Uh, looking injured. There was a 911 call." So those are those are the objective evidence for the grounds that you have imminent fear going forward. And you want to have all of that prepared, like I was saying earlier. You want to have that prepared at the time that you file the petition, right? You want to like give it some thought, like what am I going to do to boost my credibility and have other people uh, testify. And you can only bring in people who know the situation directly. You can't call in your sister or your brother say and them have she told me that the spouse hit him or her, right? The person has to actually see it to be a competent witness. Um, so the at the hearing, the petitioner goes first and has the burden of proving that they have continued fear of ongoing uh, physical harm, and the respondent, the petitioner puts on his or her evidence. It could be witnesses, it could be photographs, things that we've been talking about again and again. And then the respondent has the opportunity to cross-examine the petitioner and the petitioner's witnesses, and then the petitioner rests, and the respondent has an opportunity to put on his or her case about why the uh, respondent, why the petitioner doesn't have a fear of imminent bodily harm. It could be that I wasn't there, that wasn't me. That's kind of remote, but there could be some reasons, like um, like in the earlier case I was talking about, she wasn't scared about me. She asked me to bring home something from the grocery store later that night. There was pattern. We spent the evening together. Um, you want to look for those types of things. Say no, there was no imminent harm here. She went, after the alleged assault. She went to the supermarket, or she went out with friends, right? Or something along those lines to show that no, she wasn't. She didn't have that imminent fear. Um, Bodily um, size differentials don't count, right? So you can say, um, like even like massive, like uh, petite woman attacks massive 300-pound man who is all muscle. He can still have fear, right? It's imminent fear of bodily harm. Doesn't mean that she's going to be able to inflict it, but he can still have that fear of the bodily harm. So like that size differential won't get you anywhere. It may work the other way. Big guy, um, and a petite woman. Yeah, then certainly that person has more credible fear of being harmed. But it doesn't necessarily work the other way around. Um, if uh, um, the and so the options at the hearing, the judge's options at the hearing after the judge hears the case, the judge may decide that there's um, grounds to uphold the petition. The, the judge may decide to dismiss the petition. The judge can modify the petition. If there are children, the judge can modify the custody and parenting time provisions. Uh, the um, uh, petition is good for 2 years from the date of filing. So you still may have another 2 years to run if somebody prevails on the petition. Um, if somebody files I didn't mention this earlier, but once the petition is filed, if respondent owns guns, he may be or she may be required to surrender their firearms, and the sheriff will come out and get those, or is supposed to. And the only way that this, I said, the only way that this can terminate short of 2 years is it's superseded by um, a divorce order is modified in the court or is otherwise dissolved. Perhaps the couple figure out a way to reconcile, or they reconcile, and they can go to the court and ask that the respondent be that the restraining order be terminated. So, how are restraining orders enforced? Um, so, I just want to give an example. Something that happened to a client years ago. The client was at a Home Depot. I specifically remember it was a Home Depot, and she had a restraining order against her spouse. And I think legitimately, um, he didn't know she was there, and they ran into each other coming around those big aisles at a Home Depot. And um, he's looked up, he saw the spouse, and he said, "Oh, hi," realized what he'd done and walked away. That intentional contact was enough to violate the restraining order. So she filed a police report, and he was convicted of violating the restraining order. So there are criminal penalties under Oregon law. The site is ORS 163192. It's called Endangering a Person Protected by a Family Abuse Protective Order Restraining Act, and is a Class C to violate a felony. Uh, I misspoke. It's a Class C felony to violate the restraining order. And like the example of that case was that it didn't take much. It was the high, which got him in trouble. If he just turned away, he probably would have been okay. I personally thought that was a little bit much because it was a reflex. Like he ran into his wife, even though they were estranged and hating each other. And he said, "Oh, hi." So I don't think he had the intentionality element there, but that was still um, it was he was still convicted of that. Um, the other thing, the last thing I want to talk about is what is the impact of a FAPA on a dissolution? And the answer is none unless there are children. So having a FAPA order doesn't get you any better property settlement. It doesn't get you any better spousal support. It doesn't get you any reduced debt. Um, but if there are children, um, the person who is convicted is found has the restraining order against that person cannot by statute get custody of the kids. They may still have parenting time, but they will not get custody by statute. So um, uh, if you are in a dissolution proceeding and somebody brings a FAPA against you, there are consequences that will carry over into the divorce. Only with regard to the custody of the kids, but obviously that's still a big deal for many people. So I think that's about it. That's everything about FAPAs that I know. The other thing I was thinking about this. Theoretically, um, um, there's no spousal immunity, right? So you can sue if your spouse beats you up, you can sue them in civil court for an assault. And so um, you may you may still have a damages claim against your abuser beyond like if two strangers um, get into a fight and uh, um, let's just say the issue is not like who started it, but one person beats the other up, right? And the victim gets sued. I misspoke. The victim brings a assault case against the perpetrator of the abuse, the assault. You can still win a damages award against them. And I've often thought um, that abused victims had the right to sue for damages. It may be a little technical about like how it would actually be done, like whether it be consolidated with the dissolution or it's a separate action, and that gets into jury trial and due process. Uh, but you don't. I don't think you won't get more from the dissolution, but you certainly may be entitled to more as a result of being the victim. So that's something to think about too. Is that an abuse victim may have civil rights and remedies that are available to them, even though what I've just said is rarely, if ever, pursued by uh, family law attorneys. So that's it. My name is Stephen Leskin. You can reach me at leskinlaw.com. Like I said, I'm happy to take questions if you're watching this on YouTube or later. Give me a call. I'll be happy to answer some questions. My phone number is 971-930-4716. My email is stephenleskin@leskinlaw. Thanks for watching. I hope this has been helpful to you.